to the World Trade Organization, what case law do they use when they're deciding any of these cases?
In terms of precedent?
Yes, U.S. Supreme Court I understand, Maine Supreme Court I understand, but I don't understand where they get there.
To the best of my knowledge, they don't have any to go on.
The Surface Water Act in Title 22 was actually, it was very careful, although it was an amendment, a late-minute amendment appropriation, it was very carefully crafted. There was a 1982 U.S. Supreme Court case, Sporhase versus Nebraska, which essentially held that it would violate Article 1, Section 8, Clause 3 of the U.S. Constitution, the Interstate Commerce Clause, to have a straight prohibition of interstate commerce in groundwater. So what the legislature did was say, well, we're not going to deal with crossing state boundaries. We're going to deal with crossing municipal boundaries. And so that's how the statute is crafted. It's not been actually reviewed by a court to see whether that does or does not somehow violate the Interstate Commerce Clause.
Yeah, actually, the bulk water transport law you pointed out was an amendment to an appropriations bill that Pat McGowan actually was the author of that amendment at the time, and I looked very thoroughly for the legislative debate, and there was none. So
That's true.
Does the state, in fact, own the water that's flowing down the brook?
I think it does.
Really?
I'm not positive.
Oh, that's interesting.
But I think it does.
Yeah, I'm not sure. I just
The largest dividing the country is the concept of riparian use versus appropriation. Basically, in the eastern United States, we have riparian rights. Water is owned, the surface water, as Jim is describing in the stream, is owned by the public, but private parties have the ability to use the water as long as they don't harm the downstream use. In the West, it's appropriation, which is you got there first, you got it for as much as you can use, and then the next person for as much as he or she can use, and so forth. So you have riparian and appropriation. Then you have the various doctrines of reasonable use, absolute dominion, and so forth, which deal with the regulatory environment and some overlap of ownership. But I think Jim is correct that what we've done over the years in Maine is taken the ownership concept of groundwater, which in the very, very largest picture of ownership, if a person owns a piece of land, the concept is that person owns to the center of the earth to the tops of the skies. And there's a fancy Latin expression that we all learned in Latin in law school, and I can't remember what it is. But the fact that you own property doesn't mean that it can't be regulated. As Peggy has properly pointed out, regulation under the police powers is not a taking. So the state can regulate what you own. So in terms of groundwater, you own the groundwater, you own to the center of the earth, you own what's there, but it can be regulated. So there's this conflicting concepts of ownership versus what's regulated. And I think Jim is absolutely correct that over time, Maine has adopted a large number of regulations that are set out in Paul's paper. What Paul's paper doesn't, I think, also show quite as much is the local regulation.
Right.
Local communities also regulate water withdrawals, water uses. So we're really, it's such an amalgam that it's now gotten to be in a common sense term, a reasonable use. Reasonable use is also got technical aspects to it, and we're not in the capitally reasonable use, but we're in the concept of reasonable use. That is, someone might own it, but it is fully and heavily regulated.
And on the local can supersede the state's rulings or regulations, but they can't fall under them.
Well, local it's simply home rule authority, and as long as the locals don't directly conflict with a state statute or have a regime that can, or have state regime, then the locals can do what they want.
Right, and basically, if the legislature decides it wants to preempt a field, it believes the matter is so important that it wants a uniform state policy, then it can establish certain parameters and sometimes can actually preempt the articulation of municipal police power. But that's the exception rather than the rule.
Under the doctrine of absolute dominion, can the state allocate groundwater, allocate uses of groundwater?
Under the doctrine of absolute dominion? No, I think under that doctrine, which, as has been mentioned, has been modified, but under that doctrine, pretty much the property owner can do whatever it wants with the groundwater.
So is that really what's behind this move to transfer the ownership of groundwater from property owners to the state? Because I can't see an advantage environmentally why we would do that. So I'm trying to figure out what the other advantage may be.
I really can't speak to that. I do know there's been a lot of literature, a lot of writing about trying to migrate to public trust in terms of many critics of the current regulatory regime point out that the relevancy of absolute dominion has passed, that because we now understand transmissivities and the properties of groundwater, we didn't understand that when the country was founded. And so the question is asked, well, why can't you treat groundwater resources the way you do tidal waters? Because after all, we do understand how water behaves these days.
We have a rather unique situation, I think, from the time we were part of Massachusetts, in that the common law was changed a little bit where it didn't change for Vermont or New Hampshire or some of the other New England states. And with the colonial ordinances of 1641, 1647, that's had some sort of an impact on all of the case law that, I mean, mostly we have case law. I don't think we have, with the exception of some of the more recent amendments to groundwater law, most of it has been case law in anything that I have looked at, going back to the 1830s. And they go back to these colonial ordinances and mention those. But, you know, the question is, you know, I'm beginning to feel a lot more comfortable with what we did in 2007. I felt comfortable at that point with it. And the question that I always have is, you know, what's the long-term impact on ownership and control, and what is the long-term impact of those, which Carol nicely pointed out, those dry areas down in the south? You know, at some point there's going to be the movement of a large amount of water, and it's not going to be in bottles. It's going to be in pipelines or something else. It's, you know, it's bottled water is rather limited impact, I think. It's the long-term question of how are these resources going to get allocated and to whom that I'm most concerned with.
But wasn't one of the first laws passed by the legislature stop piping over the state line and large?
I don't think you could do that. Wouldn't that, I mean,
that's what I mean, that situation has already been addressed by the legislature. Correct?
well, I don't think they can change anything that would be going over the lines. I mean, and the bulk water transport law could have something to say about that, I believe, although they haven't really said much. But I don't think that you could, I mean, the question is about allocation and what's going to happen, not 5 years from now or 10 years, but 40 years, 50 years. How is this water going to be allocated? How is it going to be moved around, not just the state of Maine, but moved around throughout the region?
The Surface Water Act in Title 22 was actually, it was very careful, although it was an amendment, a late-minute amendment appropriation, it was very carefully crafted. There was a 1982 U.S. Supreme Court case, Sporhase versus Nebraska, which essentially held that it would violate Article 1, Section 8, Clause 3 of the U.S. Constitution, the Interstate Commerce Clause, to have a straight prohibition of interstate commerce in in groundwater. So what the legislature did was say, well, we're not going to deal with crossing state boundaries. We're going to deal with crossing municipal boundaries. And so that's how the statute is crafted. It's not been actually reviewed by a court to see whether that does or does not somehow violate the Interstate Commerce Clause.
Yeah, actually, the bulk water transport law, you pointed out, was an amendment to an appropriations bill that Pat McGowan actually was the author of that amendment at the time, and I looked very thoroughly for the legislative debate, and there was none. So
That's true.